Good morning, everyone, and welcome. We're pleased to have you with us this morning. Counsel, your case is very special to us. It's the only one we have this morning, so we're counting on you to deliver very impressive arguments and convincing theories. I want to remind you that each of you has a total of 15 minutes to present your argument. The appellant has the right to reserve up to 5 minutes for rebuttal. So when you come to the podium, let us know how many minutes to reserve and we'll program the clock accordingly. I assume we have some guests here. Can anyone identify who our guests are today?
Your Honor, my client is here, as well as her parents, her husband, and a friend.
All right. Well, the family support then. All right. And we trust that yours are at home watching. And okay. Well, very good. Glad to have you with us as well. All right. Well, call the first case, please.
Esther, Lynn, Bowman versus Paul Chapman Smith, Jr.
Good morning, Your Honor. I'm Tracy Knight of the Montgomery County Bar for the appellant, Esther Bowman, and I'd like to reserve 3 minutes for rebuttal.
3 minutes, certainly. You may begin.
Your Honor, this case originated as a petition filed by my client seeking permission to relocate with the children to Texas. This appeal is not about the trial court's decision denying the relocation, but instead is about the trial court's changing of a primary residential parent designation from the mother to the father based on father's counter petition alleging a material change of circumstances. This material change was not independently pled, but only after mother sought permission to relocate. A little history of this case. The parties divorced by agreement in 2021. The agreed parenting plan designated the mother as the primary residential parent and granted the father 80 days of parenting time. By agreement, the parties modified that parenting plan a year later in 2022. The modified plan also designated the mother as the primary residential parent and increased the father's time from 80 days to 107 days. At the time of the divorce, at the time of the 2022 modification, and at the trial in this matter, the mother resided with her parents in Sumner County. The children enjoyed a strong bond with their grandparents, having resided with them for a long period of time. At the time of the trial and at the time of the 2022 modification of the parenting plan, father resided in Montgomery County in his current home with his current wife. After a 2-day trial, the trial court denied the relocation request. The October 2024 final order did not, however, follow Tennessee Code Annotated 366108, the relocation statute. It did not outline a parenting plan which would take effect only in the event the mother chose to relocate without the minor children. But instead, I'm sorry?
Hadn't she already announced her intent to relocate?
I think she was seeking permission to relocate. It is my understanding that she had not announced that she was intending to relocate without the children.
I don't see the difference, but you can go ahead.
Okay. Instead, the trial court changed the primary residential parent designation to the father and reduced mother's parenting time dramatically. The record does not illustrate a material change of circumstance that affects the children's well-being in a material and meaningful way. Before a best interest analysis is done, the court must first find a material change of circumstance that affects the children's well-being in some meaningful way.
And that's the only issue that you've raised here with respect to the final permanent parenting plan, that you're saying there wasn't a material change in circumstance significant enough to warrant a change in custody.
Yes, Your Honor.
Okay.
Yes.
So the material change was dealt with mother's travel, frequent travel to Texas, correct?
I believe the material change was father's retirement from the United States military.
Well, that too, but it didn't her travel to Texas figure into it?
It's my understanding, I was not on the case at the trial level, but it's my
Well,
understanding.
you should know anyway.
Yeah, her travel, I believe, was on time that she was not, the children were not with her.
Okay.
But she would travel for 2 weeks at a time. So you're saying she, under that plan, she would go 2 weeks without seeing the children
I'm sorry, Your Honor.
even before she moved to Texas or married and was dating the gentleman in Texas.
The children would travel with her when there were times that they were out of school.
But when they were in school, didn't she have visitation more frequent than 2 week intervals?
Yes, and she exercised all of that time.
Right, except for when she traveled to Texas.
Those, I believe, the times were when she did not have the children, when she would travel.
But that's my point. What I hear you saying is the parenting plan in effect at the time when she was going to Texas for 2 weeks. What I hear you saying is that she would not see the children under the parenting plan for 2 weeks.
No, no, sir, I'm sorry.
Okay.
I don't mean to be saying that at all. That is not.
So she was going for 2 weeks, but foregoing some of the modest parenting time that she would have had.
No, she exercised all of her parenting time, and the children traveled with her for longer periods of time to Texas when they were out of school.
But you said she only did that during the summer and vacations.
Yes, when they were out of school.
Okay, but again, I'm going to ask you the question. What I hear you saying is that under the parenting plan, she would not see the children for 2 weeks.
If it was father's parenting time that was under the parenting plan, if it was father's designated time.
But was it 2 weeks on and 2 weeks off? I don't think it was.
I don't think it was.
Okay.
No.
Then, well, I don't think you're going to answer my question, but go ahead.
Okay, I'm sorry about that. A Rule 59 motion was filed and a hearing was held. The trial court then changed course and entered an amended final order, which reversed the original final order, reinstated the 2022 plan, and ordered the parties to go to mediation. Unsurprisingly, mediation was not successful, as it was ordered after 2 days of trial and a Rule 59 hearing. The court then entered a final amended order on January 7th, 2025, naming the father primary residential parent and granted mother 145 days of parenting time. The final amended order also included language that the plan would spring to a 50-50 plan if the mother relocated from Sumner County and moved within 30 miles of the father. Mother's living situation had not changed since the 2021 divorce, and father had resided in the same home with his current wife since and before the 2022 modified plan. Father retired from the military in 2024, but failed to illustrate how that change materially affected the children in a meaningful way. Father testified that his current job requires him to spend every other week in Humboldt, Tennessee, 2 hours from Clarksville. On those weeks, the children stay in Clarksville with the stepmother. At the time of the 2022 parenting plan modification, father was in a non-deployable position with the military and anticipated his military retirement in the near future. The trial court relied on father's retirement as a material change, but did not outline how father's retirement affected the children in a meaningful way. The court instead went forward with a best interest analysis. Father failed to prove how the children's well-being had changed in a material way since the entry of the 2022 modified plan.
Well, the court in its final order does reference stressors on the children. So I read into that there was some concern about how the then current plan was working.
There was a reference to stressors on the children. Your Honor, there were no medical records illustrating any material change or stressors. There was no psychologist or medical expert to give testimony with regard to stressors or well-being, and there was no GAL appointed in this
The
case.
court did hear from the children, though,
Yes.
in camera, and there was some testimony, it seems, about mother's relation or living situation at the time being a concern for both children, were there not?
There was a question of that. However, the children in their testimony both stated that they enjoyed living with the mother and the grandparents.
So the stressor was,
The younger child had some anxiety issues, and there was quite a bit of testimony with regard to that from both my client and the father. The children were also asked about her anxiety, the younger child, Kennedy. Your Honors, the father failed to prove how the children's well-being has changed in a material way since the entry of the 2022 Modified Parenting Plan. Under the current plan, the children spend more time with a step-parent than either natural parent because of father's work schedule, which has him working in Humboldt, Tennessee, every other week. The judge voiced concerns about the stepmother's statements about the mother in the presence of the children. However, the children in this case spend more time with her than with either of their parents.
Well, how do you figure that? You say more time.
Father's schedule is that he works 4 day shifts, has 24 hours off, and then 3 night shifts in Humboldt, Tennessee.
and then he has a week off.
Then he has a week off.
Okay, so I'm trying to figure out how it's more time with the stepmother.
The stepmother is with the children during that time period when father is
Well, that's
in
half-
Humboldt, Tennessee.
That's half the time if we,
Weeks.
okay. So
The week that father is home, the
way I
7 day
under-
period.
The way I understood, and that maybe I misunderstood what you were saying, is that the father wasn't around
He's not around for one of the 2 weeks, sir.
for one of the 2 weeks, but he is the other week.
Yes, sir.
All right, thank you. Okay.
That's all I have, Your Honor.
All right, thank you. You'll have time for a rebuttal.
Thank you.
Good morning.
Good morning. I'm Stacy Turner, and I represent Paul Smith. And I represented Paul at the trial of this matter, which I think gives me a little bit more insight. Ms. Knight did not represent Ms. Bowman at trial. And I think that's important because it emphasizes the cases that I've presented in my brief that stand for the proposition that trial courts are in a unique position and given broad discretion, wide latitude, and great deference in determining custody cases because they see the proof, they determine the facts, and they see the witnesses, how they testify, their demeanor, their credibility, and that was a large part of this case and why I think the judge ruled the way she did. It's not just factual questions. Custody cases, the case law that I presented, sometimes hinge on subtle factors, and that is the credibility and the demeanor. In that case, the case law says that the trial court has sovereign realm with regard to those determinations. And being counsel at the trial has given me a greater understanding as to why the court found the way that it found. And
This case has an unusual procedural history in that it started with a parental relocation.
It did.
And then the court ruled on that.
no, I filed a counter petition when she filed the parental relocation. I filed a counter petition heard within the same 2-day trial for a modification of custody.
All right. Now, did the trial court make findings of fact as to material change of circumstances relative to mother not relocating? In other words,
Yes.
mother staying in the Clarksville, Sumner
Yes.
County area?
There were multiple findings of fact in the courts, and I want to go over a few of those and the court's concern and why I think the court ruled the way it did. One of the concerns, the first concern that the court had was the mother's instability in her living situation and how that affected the children adversely. After the last order of June 9th of 2022, the mother graduated from nursing school and began working at Vanderbilt on a night shift. And she was working 3 nights a week on the regular, and then every 5th week, I think her testimony that was at transcript 117, picked up an extra shift. So it was 4 nights a week on the 5th week. And the court found that she was essentially leaving the children unattended. They were at her parents' home, but her father was in poor health, and her stepmother, who testified, the court found that she had no idea when the mother was working, when she wasn't, when she was supposed to be caring for the children. And the children.
Well, I saw that in the testimony, but the way I read that is that, you know, she's going to be available when she's needed to be available. I don't think that was an indication that she really wasn't aware that she needed to be available to care for the children.
Right, but it wasn't only that. It was some of the text messages that I spoke with Ms. Bowman about, that the youngest child that had such anxiety was texting her during the night.
Let me ask you this question, counsel.
Okay.
And we obviously, as you're well aware, material change of circumstance to change the primary residential parent is a higher standard.
Yes, it is.
And what is a little bit striking in the court's findings in this case is, you know, the finding that the children are well adjusted, despite the concerns and the stressors. And, you know, typically you don't find that sort of finding with a change in primary residential parent because you're looking for some substantial effect on the children. So how does that work in, or how should that work into our consideration of whether or not the evidence preponderates here?
And again, I think you got to consider some of the facts that were also presented along with that statement in an order, and what the court found, especially when the court was questioning mother about her youngest child's anxiety and all of the extreme texts that she was sending late into the night. The child was not sleeping at night. Mother was not there. The grandmother was not available. The court asked her, she said, you know, why haven't you changed your living situation when you know that this is causing such stress on your child? And the mother minimized that, and that's one of the findings that the court found, that her credibility was at issue with regard to her minimizing the anxiety that her children were suffering because she was working at night. She didn't change her work schedule, and she didn't change her living situations.
Well, a child having anxiety can come from many sources. What was it about the mother's parents' home that was causing anxiety? You said the mother should have changed her living situation. What was it about that home?
Because she was afraid to go talk to her grandmother and tell her grandmother that she was having issues. She was afraid to get out of the bed. She was hearing noises. You know, her mother was not there. And she needed her mother, and her mother was not there, and she left her in the care of someone that the child did not want to go to, or was afraid to go to, was afraid to get out of bed, was saying, pray for me, pray for me, pray for me. Those text messages were very extreme with regard to this youngest child.
But by the same token, didn't we have testimony from both children that they like living with mother?
No, I disagree with that.
Okay.
The oldest child especially, I think the youngest child was just, she had a lot of anxiety when she was being questioned by the court. The oldest child said she did not like living in grandparents' home. She didn't like going back and forth to Texas.
Well, I'm talking about being with the mother, though. I appreciate that there was testimony concerned about privacy in the grandparents' home and
Yes.
not having, you know, enough privacy.
She said she didn't like living there.
But what about being with mother, though?
What she told the court was that she felt more comfortable with mom than with dad. And the court inquired about that, was trying to get a little bit more information. And she ultimately told the court, and I think it's just because I haven't lived with dad enough, I've lived with mom more, and that's the only reason that I feel more comfortable. But other than that, there was nothing else that referred to preference at all. And I think the court...
It was just comfort, more
Yes.
comfortable there. I
Yes.
see. Okay.
Okay. Another issue...
Let me ask this sort
yes.
of related question is, mother remarried
Yes.
after the last plan.
and I was getting to that as my next
Well, and
area.
I suspect you will. I'm going to concentrate a little bit on the other side of that, because I'm assuming you're going to spend some time on Mr. Bowman. But the court focused a lot on mother's existing living arrangement, which is not inappropriate, of course. But by virtue of the fact that she had remarried, it seemed like to me that there should have been equal time concentrating on what mom's future living conditions were going to be, rather than focusing so much on, well, she's staying with the grandparents. I mean, is that not
Right, and
a
the
problem?
court did. We heard a lot of proof on that. And the mother's relationship and subsequent marriage to Mr. Bowman, the court had concerns about that. She had never lived with him. He lived in Texas. Mother's answer to her problems and living situation were to pick these children up from Tennessee, where her father was, mother's family, every relative they had here was in Tennessee. There were no relatives in Texas. Moved to Texas with a man that she had never lived with. He had a home, but she had no ownership interest in that home. And the former Mrs. Bowman, Mr. Bowman's ex-wife, testified about a history of domestic abuse, verbal abuse, emotional abuse. That was concerning to the court, and Mr. Bowman testified. Both the former Miss Bowman and Mr. Bowman testified about the extreme high conflict relationship that they had between them with their two children. And the former Miss Bowman said, this is not a good house for these children to be in. Mr. Bowman, although they shared time in Texas, talked about boundaries that he had with his former wife, that these two children had special needs, and he would not allow her to have any medical appointments on his weeks because he didn't want to be in the same room with her.
And this is Mr. Bowman's children by the...
Yes.
Okay.
It was that testimony, unless you sat through that, it was palpable with regard to how that came across. And that was a huge concern for the court, so much so that at the close of the proof, the court told Ms. Bowman, and that's found at the transcript starting at page 487, that her plan to move to Texas with these children was, and the trial court used the word absurd, because she went on to say that if you think Mr. Bowman, the man you've married, is going to help you raise these two children when he cannot even have respect for the mother of his own two children, and has such a contentious, high conflict relationship, that's not going to happen. It's a ridiculous thought. And the court was very concerned about the environment those children were going to be in with regard to that high conflict relationship in Mr. Bowman's home. So that was a huge concern for the court. So much so that the court went on at the close of the proof to tell the mother, and that's in that 487 transcript, gave the mother 10 days to withdraw her petition, and said, y'all meet together and try to come to an agreement for a new parenting plan that's in these children's best interest, and if you don't, I will issue my ruling. No petition was withdrawn, and the ruling was entered on October 31st of 2024, denying the relocation, giving father primary parent status because of the inference that mother was going to relocate to Texas. Another concern that the court had in the findings of fact and in the transcript was the mother's unwillingness to co-parent with the father and minimizing his involvement with the parenting of the children. They communicated through the Our Family Wizard parenting app, and I submitted excerpts from that parenting app where my client was trying to communicate with mother to discuss the children's issues such as education, medical, grades, extracurricular activity, the youngest child's severe anxiety and therapy, and social media issues, especially with the older child. The mother would make decisions without notifying the father. She refused to talk to him in the parenting app, and I submitted several excerpts. Those are exhibits to the trial where she just didn't respond when he had concerns. That was very concerning to the court. There was an incident with the oldest child in a group chat that the father brought through the app to talk to the mother, and she said, I'm not going to talk to you about this. And then at a physical exchange of the child, he tried to talk to her, and she refused to talk to him and left, and that's when the comment from the stepmother came in. You know, you need to talk to us, don't be, and she used a word. But that was the comment when the mother would not talk to them and co-parent with them. Additionally, After the order was entered, there was, the mother filed the Rule 59 motion, and we were in court on December 6th, and the court reiterated its ruling because the mother in her Rule 59 motion said, Judge, you got it wrong. You need to let me relocate to Texas. It wasn't about, we need to do a new parenting plan here. It was, you were wrong in not allowing me to relocate to Texas. The court reiterated its findings as to why it didn't allow the relocation, and I stood up. That was the first time the mother said, well, I'm not going to Texas, I'll stay here. And I stood up at that time and said, you know, I've spoken with Mother's Council. We're willing to try to work out a 50-50 plan, and that's why the court suspended its order and sent us to mediation. Again, the court, for the second time, was trying to get us to work this out with her staying here. We went to mediation, and it didn't resolve the issues.
To what extent did the court's order, after the relocation was withdrawn, withdrawn, to what extent did the court make findings as to material change of circumstances that did not relate to relocation?
That was, again, the father's minimizing, the mother's minimizing of the father's parenting, her credibility there, her not co-parenting with him, the continued concern about the environment if the mother remained married to Mr. Bowman that these children were going to be in, and the issue of her living situation and her working at night. Those were the three major areas of material change in circumstances that the court laid out in its final amended order, going further to talk about mother's credibility and the demeanor of the witnesses when we didn't reach an agreement in mediation. And after that final order was entered, because the judge wanted to have it entered before the children started the fresh spring semester, the order was entered on January 7th. That's the day that the children started school. The mother refused to turn the children over to the father or allow him to come get them. They missed 7 days of school. Mother hired new counsel in the county that she's in to file a stay, filed for a stay. We filed for a show cause after the children had missed 7 days of school. The trial court denied the mother's request for a stay and wrote in the order, if you don't turn these children over, you could face incarceration. That day is when she turned the children over. So we would submit, Your Honors, that the trial court made the appropriate material findings of fact for material change of circumstances, and we would ask Your Honors to approve and affirm her ruling in every aspect. And we've also asked for attorney's fees. We think under TCA 271122 and Galloway versus Scott that this appeal meets the definition of a frivolous appeal as defined there as devoid of merit or reasonable chance of succeeding. And we would ask for attorney's fees as well.
Are you only seeking attorney's fees under frivolous appeal as opposed to under the custodial statute?
We would ask for attorney's fees under both, Judge. We think this is an appropriate case.
Well, but you didn't.
Did you in the brief?
I did not, Judge.
Okay.
I just, under Galloway versus Scott, yes.
Okay. All right. Thank you, Ms. Turner.
Thank you.
All right. Ms. Knight? What do you say about the trial court's findings of fact as to material change of circumstance after it was decided that mother would not relocate to Texas?
I believe that the court was attempting to state that father's retirement from the United States military and the anxiety of the minor child Kennedy were the two changes. That is how it reads. However, that is the order that states these children are well adjusted.
Didn't the court also say father had suitable housing, provided significantly more structure for the children, and appeared credible in his desire to facilitate the relationship between the children and their mother?
That was in the order. The housing was the same housing that father had at the time of the 2022 modification, and he was married to his current wife at that time. Also, Your Honor, with regard to the children refusing to go with father after the order in January, we have a 15-year-old and a 12-year-old who did not want the change in the plan and were refusing to go. And so
Their testimony would indicate otherwise.
their testimony after the amended final order?
Their testimony in chambers would indicate that they had no problem being with father.
Well, they did not want, after the amended final order, they did not want to go
Well,
with father.
There's no evidence of that in this record.
Okay. Your Honor, with regard to the children's testimony, they did state that they wanted to go to Texas. They wanted to stay with the mother, that they felt more comfortable with the mother. So I think they did enjoy spending time with their father, but did not want to be with him full-time as a primary residential parent. With regard to my client's night schedule and working as a night shift nurse, that allowed her to make breakfast for the children, to get them to school, to pick them up from school, to spend time with them after school, and to work when they were sleeping. With regard to the stepmother's testimony, she stated that she was there all the time with the children, should they need it. When she stated she didn't know what was going on or where they were, that was with regard to a question regarding paid time off, vacations with my client and her husband.
Stepmother or the grandmother?
My client's stepmother.
Oh, I'm
The
sorry.
grandmother of the children.
I'm sorry, thank you.
Yes. So they were attended by her and by my client's father at all times. And the children had a close relationship with them, didn't want to leave that household. And the grandmother was always available. The children had a close relationship with the grandmother and with the grandfather. The case law stated in Ms. Turner's brief is misplaced, Your Honor. A lot of this is very different from the case we have here. In Ray, TCD had a mother and her family referring to the father as a guest, and other negative names. And we don't see that in this case. These parties did get along for the most part. They did have some communication issues. Mother was working and could not respond to father in a timely manner a lot of times. She's a nurse at Vanderbilt, so when he sent a text to her over an app, she was unable to respond immediately to him, and that was a problem for him in his testimony. But they did communicate, and they did work well together for the most part. We contend that there was not a material change that affected the children's well-being in a meaningful way to make a change of a primary residential parent and move forward with a best interest analysis, and would ask that this court reverse the trial court's order with regard to primary residential parent designation.
All right. Thank you very much, Ms. Knight and Ms. Turner. We appreciate your arguments, and we'll take this matter under advisement. And to the parents, we want you to know we take these cases very serious, and we'll do the best we can. Thank you. That concludes the morning docket.